start. As far as the observation to the effect that the court should have appointed amicus curiae is in a different realm. Stop. It is one thing to say that the court should have appointed an amicus curiae, and it is another thing to say that the court cannot decide a criminal appeal in the absence of a counsel for the accused, and that too even if he deliberately does not appear or shows a negligent attitude in putting his appearance to argue the matter. Stop. With great respect, we are disposed to think, had the decision in Bunny Singh been brought to the notice of the learned judges, the view would have been different. Stop stanza. In view of the aforesaid enunciation of law, it can safely be concluded that the dictum in Muhammad Sukur Ali to the effect that the court cannot decide a criminal appeal in the absence of the counsel for the accused, and that too if the counsel does not appear deliberately or shows negligence in appearing, being contrary to the ratio laid down by the larger bench in Bunny Singh, is per incurium. Stop. We may hasten to clarify that, barring the said aspect, we do not intend to say anything on the said judgment as far as engagement of amicus curiae or the decision rendered regard being had to the obtaining factual metrics therein, or the role of the bar association or the lawyers. Stop. Thus the contention of the learned counsel for the appellant that the High Court should not have decided the appeal on its merits without the presence of the counsel does not deserve acceptance. Stop. That apart, it is noticeable that after the judgment was dictated in open court, the counsel appeared and he was allowed to put forth his submissions, and the same have been dealt with. Stop stanza. At this juncture, we are obligated to state that in certain cases this court had remitted the matters to the High Court for fresh hearing, and in certain cases the burden has been taken by this court. Stop. If we allow ourselves to say so, it depends upon the facts of each case. Stop. In the present case, as we perceive, the High Court has dealt with all the contentions raised in the memorandum of appeal and heard the learned counsel at a later stage, and hence we think it apposite to advert to the contentions raised by the learned counsel for the appellant as regards the merits of the case. Stop stanza. On merits, it has been argued that the essential ingredients of Section 7 of the Act have not established, inasmuch as no official work was pending with the appellant accused and the allotment work was done by the manager, and hence he could not have shown any official favor. Stop. It has also been contended that mere recovery of bribed money from the possession of the accused is not sufficient to establish the offence, and it is the duty of the prosecution to prove the demand and acceptance of money as illegal gratification, but the same has not been proven at all. Stop.